Welcome to our estate conservation seminar on preserving wealth for your heirs. I'm glad that you could join us today. I am one of the three instructors. I'm Kelly Bufink. And before we begin, we need to go over our disclaimers. Today's information is for educational purposes only, and it should not be intended as any specific legal or tax advice. If you would, please take a moment to read through these disclaimers, and if you'd like more information, please visit our website listed on the page at the bottom. Again, my name is Kelly Bufink. I am your instructor for today. I was born and raised here in Texas. I've been an advisor since 2001. I have a degree in psychology and English from the University of Maryland University College. I am an Army wife of over 30 years, and in my free time, you'll find me with my husband and our two dinosaur of dogs and our 4 children whom we now visit across the country. Here's a little bit about our firm. We are Strip Matter Wealth Management Group. We were founded in 2007, and we are comprised of certified financial planners and fiduciaries, and education is our passion. We specialize in comprehensive financial planning, which includes estate planning. And because education is our passion, we have a variety of free resources for you that you can find on our website, stripmatterwealth.com. Here are the class objectives for today. First, we want to help you get a better understanding of what estate planning is overall, understand the different documents used in estate planning, and help you begin to prepare or update your own estate plan. But I want you to take a moment and write down, what do you want to get out of your time today? Feel free to pause here and write these items down. We have a number of things to cover today. We'll go over the benefits of estate conservation, intestacy and how it affects estate distribution, probate and ways to avoid it, calculating your tax liability, current estate law, tax strategies that could help reduce taxes, and estate distribution techniques, including will, trust, and charitable giving. So let's get started. In today's seminar, we're going to discuss some of the estate conservation principles that can help you avoid the kind of confusion and discord that some estates, even those of the not so rich and famous, may encounter. First, we'll discuss the key fundamentals of estate conservation. Then we'll identify challenges you could face as you plan your estate. We'll run through a few basic distribution techniques that could be used for managing your estate and dividing your assets among heirs. And finally, we'll talk about the number of trust strategies that can give you and your heirs additional privacy and protection, and that can also be used for charitable giving. First of all, what is an estate? Your estate is simply all the wealth you've accumulated during your lifetime. That includes your real estate, stocks, bonds, business interests, retirement plans, life insurance, personal effects, and anything else you own. Once you have listed all of your assets, whether they're tangible, investments, cash, or life insurance policies, you'll need to subtract out your liabilities. Your liabilities are anything you owe to somebody else, your mortgages, your bank loans, your credit cards, unsecured debt, etc. Once you subtract out your liabilities from your assets, that leaves you the net value of your estate. It's important to know what this number is today because that's where you're planning. However, it's more important to know what that number is in future years or when you actually pass away. That's the figure you want to be planning for. Effective estate conservation has several benefits for all people, not just those who are very wealthy. Estate conservation enables you to select who will receive your assets. It can help you determine the distribution of your estate, which means you decide if, how, and when your beneficiaries will receive their inheritance. It will enable you to choose individuals who will manage your estate after you pass away, including an executor, a trustee, and others. It can help reduce estate settlement costs, including probate expenses and taxes. And if your children are young, it will enable you to choose a guardian for them. Or if you're the guardian for an adult or a special needs person, you'll be able to choose a guardian for them as well. Finally, effective estate conservation can help provide liquid capital to cover burial, settlement, and income tax costs. So let me ask you this question. Is having a basic understanding of estate planning beneficial for everyone, regardless of their current asset size? Yes, it is. Okay. Your next step is to begin documenting your assets and your potential beneficiaries. Now that we have reviewed some estate conservation fundamentals, let's focus on some challenges you may encounter as you develop your estate conservation strategy. Most people face four main estate challenges: finding the right attorney, probate, taxes, and long-term care. Let's go through them one at a time. The first challenge many people think of is finding the right attorney. The fact is, an attorney can be an essential part of your estate conservation team, and finding the appropriate legal professional to handle your estate can make a tremendous difference for you and your family. Only an attorney or an attorney-created platform can draw up the legal documents and agreements necessary for certain estate conservation strategies to work properly. Any successful estate planning effort will be the result of several professionals working together, and a qualified attorney is a critical member of this team. You'll also want an attorney who's willing to work with other professionals. Finding the right attorney might involve a little bit of research. You may ask referrals from friends or from financial professionals. You can also contact the local bar association and ask for names of attorneys on the probate or trust committees. There are ongoing expenses associated with the creation and maintenance of legal documents and arrangements, along with the attorney fees. Another state conservation challenge is probate. Probate is the court proceeding that concludes all the legal and financial matters of the deceased, and through which estate assets are distributed. The probate court acts as a neutral forum in which to settle disputes that may arise over the estate. This isn't always as simple as it sounds. The probate process can be expensive and time-consuming, and it is completely public. Many people would prefer to avoid it if possible. Unfortunately, the probate system is very complex and has some serious drawbacks. Here are some facts about probate to consider. First, it can be expensive. Probate costs vary depending on the state in which probate is carried out. Through all states require the payment of court fees, which may only be a few $100s. Attorney fees could add significantly to the total cost. Second, probate could take a long time. Probate may take a few months to a year or even more. Your beneficiaries may have to wait until probate is concluded to receive the bulk of their inheritance. Third, probate offers no privacy. In most states, the proceedings of the probate courts are a matter of public record. This means your heirs will have no privacy. Unless you take specific steps to safeguard your privacy, almost anyone can go down to the probate court after your death and find out exactly how much you owned, as well as how much you owed and to whom. Another challenge in estate planning is taxes. Estate taxes are levied by the federal government in some states on a property that passes from the dead to the living. All of your assets, whatever the form of ownership, are subject to federal estate tax and possibly to state or inheritance tax. Even if the estate doesn't affect your estate, the step-up in basis on inherited assets is an important consideration that might affect your gifting strategies. We'll talk about that in a little bit. Some of the most recent estate tax laws came from the American Taxpayer Relief Act of 2012 and the Tax and Job Acts of 2017. The most recent change to our tax laws is the One Big Beautiful Bill that came into effect this year, 2026. In all of these tax laws, we have what is called a federal estate tax exclusion amount. In previous years, way back into 2010, that amount was $5 million. As the years went on, that amount went up. In the 2017 Tax Cuts and Job Act, that amount that went up all the way to $13.9 million was set to reverse back to the $5 million. However, the One Big Beautiful Bill went into act in 2026, and that changed it to $15 million. That's important to know because taxes is a significant part of estate planning. So, how do federal estate taxes work? Well, because of the high exclusion level of $15 million, very few estates will be subject to the federal estate tax. Federal estate taxes are fairly straightforward, but they are somewhat different from income taxes. Estate taxes are due on the total net value of an estate. This includes the value of everything you own, in whatever form of ownership, regardless of whether the assets have been through probate. Your estate includes the value of your home, stocks, bonds, life insurance, and everything else of value. This is simply an illustration to give you a rough idea of how federal estate taxes are calculated. The annual gift tax exclusion enables individuals to transfer up to $19,000 per year, $38,000 to married couples. Okay? So you can transfer $19,000 per year to any number of individuals free of federal gift tax. Generally, amounts exceeding this annual exclusion would be subject to the gift tax and would be applied to the taxpayer's lifetime gift tax exclusion. Now, guys, gifts don't have to be outright gifts of cash. They could be income-producing assets, they could be pieces of property, they could be family heirlooms. So, the gift tax, though, it is one that is indexed annually for inflation. Now, as a result of the Tax Cuts and Jobs Acts of 2017, individuals can make lifetime gifts up to $13.9 million. However, the One Big Beautiful Bill also increased this to $15 million for 2026. The generation skipping tax is assessed when assets move to individuals who are more than one generation below you, for example, your grandchildren, or to trust for their benefit, skipping one generation and attempting to avoid double taxation. The gift tax is imposed in addition to the federal gift and estate tax, not instead of, and it may be assessed during the donor's lifetime or after his or her death. However, the gift tax exemption is the same amount as the federal estate and gift tax lifetime exclusion. So although there is no portability of the exemption from the generation skipping tax upon death, married couples can combine their exclusions during their lifetimes to give away a total of $30 million without incurring the generation skipping tax. Now, there is a notable exception to the federal estate taxes, and that is the unlimited marital deduction. Transfers of wealth between spouses are exempt from federal estate and gift taxes. This means that regardless of the size of the estate, there will be no federal estate tax levied when one spouse dies and leaves everything to his or her surviving spouse. The surviving spouse must be a U.S. citizen, though, to qualify for the deduction. Of course, when the spouse dies, the estate will be subject to the estate taxes at that time, and only one applicable exclusion can be used at the second death. A credit then effectively exempts the portion of the estate from federal taxes. However, if the executor for the estate makes the appropriate portability election on the deceased spouse's tax return and meets the filing deadline, the surviving spouse may be able to use the deceased spouse's unused applicable exclusion in addition to his or her own. The step-up in basis refers to the way in which some inherited taxes are valued for tax purposes. The federal tax code cancels the long-term capital gains tax on appreciated assets like property or shares of stock that are held until death. And the step-up raises the owner's basis to its full market value as of the date of death. So here's an example. If you originally purchased a piece of property for $100,000 and 20 years later you sold it for $500,000, you would owe capital gains on $400,000 of appreciation. On the other hand, if you held that property until death, your basis in the property would be stepped up to $500,000, its full market value. So if your heirs later sold the property for more than that $500,000, they would owe capital gains tax only on the appreciation, the amount above the $500,000 since the time of your death. The step-up in basis rules do not apply to gifts, which are subject to the carryover basis, meaning if you gift it away during your lifetime, the heir starts off with what you paid for it. So let's use that previous example. If you gave the property to your heirs before you died, the basis of the property would be your original $100,000 purchase price. If your heirs sold the property for $500,000, they would still pay capital gain taxes on that $400,000 appreciation. So you might consider whether to keep the appreciated assets rather than gifting them to your family outright during your lifetime. Unless your estate exceeds the federal tax applicable exclusion amount, your estate would not be subject to the federal estate tax, and appreciated assets, such as that stock or property, would be stepped up to their full market value as of the date of your death. Now, some inherited assets like cash, variable annuities, tax-deferred retirement accounts, those don't receive a step-up in basis. Currently, the capital gains rate as well could reach 20% for high income tax earners, plus 3.8% if they're subject to the net investment income tax on earned income, which affects taxpayers with modified adjusted gross incomes exceeding $200,000 for single filers and $250,000 for joint filers. Long-term care is another estate planning challenge. Long-term care involves the daily medical and non-medical service people might need if they become physically or mentally disabled due to prolonged injury, illness, or cognitive impairment. Most people don't think of long-term care as an estate conservation issue, but it could become one if your estate is depleted as the result of expensive long-term care cost. So think about this question. What would happen to your estate and intended legacy if you or your spouse needed long-term care for an extended period? So, Section 2. Is it fair to say that navigating the complexities of estate planning can present various challenges? It absolutely can. So your next step is to identify and list 3 potential challenges you anticipate in your own estate planning process. So now that we've looked at some of the challenges of estate conservation, let's turn our attention to the basic distribution techniques. One of the main reasons why most people do estate planning is to control the distribution of their assets. There are 4 basic estate distribution methods. The first method is intestacy. If you die without a will or die intestate, the probate court distributes your estate according to the intestacy laws of your state. The court will appoint administrators for your state and guardians for your minor-age children or others that you are the guardian of. Wills are next. Wills are what most people think of when they think of estate planning. And indeed, wills have been used for centuries. Holding property jointly with others can affect distribution of your assets as well. Property held in joint tenants with rights of survivorship or tenants by entirety will pass automatically to the surviving co-owners. And finally, using contracts, you can pass assets directly to your designated beneficiaries. Life insurance, annuities, pensions, and retirement plans are all forms of contracts. Let's discuss these distribution techniques in greater detail. First, estate planning method we will talk about will be intestacy, which means you do nothing. That means you die without a will. There are 4 main problems with intestacy. First, the courts won't have anything to work from in determining your desires, so your estate will be distributed according to the state succession laws. As another result, the court does not know how to take account of what you may have wanted or how you may have wanted your affairs to be settled. By dying intestate, you have done nothing to help reduce or eliminate the fees and taxes brought on by your demise. In some cases, your estate may be subject to federal and some state estate taxes. Third, your estate may go through a long, expensive probate process. In many cases, your heirs may have to wait a year or more before receiving their inheritance. And finally, if you haven't named a guardian for your minor-age children or any other legal dependents, the court will determine guardianship without your input. The second technique you can use to distribute assets from your estate is a will. A will is a list of instructions that tells a judge exactly how you would like your estate to be distributed. If the probate court holds your will, the court will use it in deciding how you're to distribute your property to your heirs. In the will, you'll be able to specify exactly what you would like to give to whom. You can also use a will to leave a special message to your family or establish a memorial to a special cause. In your will, you can also appoint a guardian for your minor children or other legal dependents. And you can elect an executor or personal representative for your estate. An executor is the person responsible for carrying out the directions and requests of your will. Generally, you want to choose someone who has the time and resources to see that your wishes will be carried out. To aid in your estate planning efforts, it's important to have certain legal documents in place. They can provide instructions for how you want financial and medical decisions to be made on your behalf if you become unable to make them yourself. These documents should be kept up to date and in a secured location that is known to family members and/or your trusted professionals. Here are a few of the documents that are typically used in estate planning. A power of attorney gives a trusted individual the power and authority to act on your behalf in certain legal and financial matters. Because some power of attorney agreements will not be applicable due to a disability or an incompetency, you will need additional agreements. You should consider including more or one or more of them as part of your estate conservation efforts. A durable power of attorney for finances enables you to name a trusted individual to act on your behalf in the event that you become disabled or incapacitated. This person would make the investment and other financial decisions that would affect your overall estate until you recover. A medical power of attorney outlines your preferences and forms of medical treatment and gives the individual the authority to make medical decisions for you if you're unable to make them yourself. Another widely used strategy is the living will. It's different from a standard will in that it outlines which medical procedures you will allow in the event of a debilitating or chronic illness. Living wills are most often used to authorize termination of artificial life support in the event of a terminal illness. The third distribution technique is jointly held property. In many people's minds, property ownership is closely related to a will. Many of us have been told that there are ways to use property ownership to avoid probate. In some cases, that may be true, but there are a number of other considerations you should bear in mind. The way in which you hold the title to the property will affect how those assets will be distributed. There are three basic types of co-ownership. Perhaps the most widely used form of ownership is joint tenancy. Joint tenancy can exist whether parties involved are married or not. Almost every kind of property can be held in joint tenancy. There may be two or more co-owners, but the interest of the co-owner is not broken down into percentages. The main feature of joint tenancy is survivorship. This simply means that when any joint tenant dies, his or her interest automatically belongs to the surviving joint tenants. The second type of property ownership is tenancy by entirety. This type of co-ownership must be between married couples. Though similar to joint tenancy, tenancy by entirety treats the estate as a unit, which means that neither spouse can sell the asset without the other's consent. Its main feature is that the spouse has the right of survivorship. Tenancy by the entirety is not available in all states. The third type of property ownership is tenancy in common. This is when two or more people, up to any number, may own property as tenants in common, each tenant owning an undivided interest. That means each person owns a specified percent of the whole based on his or her contribution to the purchase of the property. Because there's survivorship feature associated with joint tenancy, there are dangers in holding property in joint tenancy with other individuals. Occasionally, there are instances in which one spouse has died and the surviving spouse takes title to the residence or other pieces of real estate with the children as joint tenants. Remember, if you change the title of your property by adding another co-owner, it creates a present gift. From that gift, there could be potential tax liabilities. And when you add other co-owners, you now expose that property to the claims of the co-owner's creditors, which could result in the potential loss of those jointly held assets. You could also lose tax benefits from the rental properties or other assets that generated tax losses because a portion of those benefits will be passed along to the other joint tenant owner. This form of property ownership can be especially important in second marriages or in families with more than one set of children. So carefully consider the effects of acquiring new assets in joint tenancy if you intend for your children to have them after your death. For example, if a newly acquired asset is in the name of both you and your spouse, they will go to the survivor, namely your spouse, and not the children. But what about states with community property laws? Currently, 9 states have community property laws: Arizona, California, Idaho, Louisiana, New Mexico, Nevada, Texas, Washington, and Wisconsin. Alaska adopted a community property system in '98, but it's optional. Under community property statutes, all property earned or acquired by either spouse during their marriage is owned in equal shares by each spouse. The essential principle is that any earnings and property acquired belong not to the producer but to the community of the married couple. For estate conservation purposes, there are no restrictions on how each spouse can give away his or her half of their community property. There is no law requiring one person to leave his or her half to the surviving spouse, although many do, of course. You can also use contracts to pass along specific assets at your death. The proceeds from the cash value of life insurance, annuity contracts, pensions, and retirement plans will pass directly to the beneficiaries you've designated on the account. There are beneficiary forms for each account, and these forms are not governed by the provisions in your will. That is why it's critical to keep your account beneficiary forms up to date. If there have been any changes in your family, such as the birth of children, a death, a divorce, you should revisit your beneficiary designations to determine whether any change is needed. Failing to designate a beneficiary on your retirement plans and any other contract means that your estate could inherit the money, which may result in those assets being distributed to unintended beneficiaries. And if you do not clearly specify your wishes, or if no beneficiary is named, your assets could be distributed according to the state succession law. Another consideration is that if you plan to leave IRA or any other work-based retirement plan assets to your children or grandchildren, be aware that they must generally be liquidated. Any of those retirement accounts that are inherited have to be liquidated within 10 years. Now, spousal beneficiaries have additional distribution options, including taking the required minimum distributions over their own life expectancy. Most contracts and retirement plans allow you to designate primary and contingent beneficiaries. And typically, you can change the beneficiaries at any time. If your primary beneficiary passes away before you do, your accounts will be distributed to the contingent beneficiaries. This seems fairly straightforward, but what happens in the event you designate your adult children as beneficiaries and one of them predeceases you? Would that child's share go to his or her siblings? Would it go to the other beneficiaries? Would it pass down to their own children? That would depend on the language of your will or on the beneficiary form. In this event, it would be helpful to understand 2 common Latin terms. Per stirpes, also called by representation, literally means by the roots, but it might be clearer to imagine the branches of a family tree, meaning if one of your beneficiaries predeceases you, his or her share would be divided up proportionately among his or her heirs upon your death, meaning it would flow down to your grandchildren. Per capita literally means by the head, indicating equal shares for each member of the group. So if one of your beneficiaries predeceases you, the division of their assets would then be split out across to the other beneficiaries. So for example, if you designated that your assets go to your children per capita and one of your children predeceased you, the assets would be divided among your surviving children, and any children of the deceased child would receive nothing. On the other hand, if the assets are designated to go to your children as per stirpes, then the assets would be equally divided upon your child's children, i.e. your grandchildren. So does it matter which method you use when specifying how your assets will be distributed upon your death? Yes. So your next step is to determine which method you would like to use to distribute your assets while alive and after death. So we've covered some estate conservation fundamentals, challenges, and basic distribution methods. Now let's look at how trust strategies can add an extra layer of control and protection. Trust can be a bit complicated, so we're going to break it down into 3 parts. First, we'll go over the fundamentals. We'll take a look at some advanced strategies, including a charitable trust. And finally, we'll examine some other considerations you should bear in mind. To start off, let's answer this question. What is a trust? The classic definition states that a trust is a legal arrangement under which one person or institution controls property given by another person for the benefit of a third party. Most people think that trusts are only for the rich, but that's not necessarily so. If properly structured, certain types of trusts can be used to help shield assets from tax liability. Some trusts can completely avoid probate, and because trusts offer some unique advantages over other estate planning methods, they may be the answer to many of your estate conservation needs. Now, the use of trusts involve a complex web of tax rules and regulations and usually involves upfront costs and ongoing administrative fees. You should consider the counsel of experienced estate planning professionals before implementing a trust strategy. Several parties can be involved in a trust. The person giving the property is referred to as the grantor or trustor or settlor. That's the person controlling the property. And the person who controls the property of the trust is called the trustee. The person for whom the trust operates is called the beneficiary. It's important to point out that you are generally allowed to be the grantor, the trustee, and the beneficiary of a trust simultaneously. Now, upon your death, any debts will be paid and your possessions will be distributed to your heirs according to the written instructions in your trust. You can maintain complete control over the distribution of your assets. There are 2 main types of trust. A testamentary trust takes effect upon your death, at which point it becomes irrevocable. It is created by your last will and testament. A living trust, also called an inter vivos trust, is created and funded while you are still alive. Utilizing this type of trust, you can name yourself as trustee. Living trusts can either be revocable or irrevocable. Both types of trust are dissolved when all the assets within the trust have been distributed to the beneficiaries according to the terms of the trust. So let's discuss them in detail. A testamentary trust enables you to control the distribution of your estate. This includes naming the trustee to manage the assets left to minor children until they reach whatever age you feel appropriate. Testamentary trusts are usually established by a will and take effect upon the death of the grantor. Thus, when you use a testamentary trust, the assets in your estate will still go through probate, with all the costs and delays the probate process can bring. Although a testamentary trust does not result in any immediate estate or income tax savings upon the death of the grantor, it can be very useful in helping reduce estate taxes as the property passes to successive beneficiaries. A living trust also enables you to control the transfer of your assets to your beneficiaries. But unlike a testamentary trust, a properly structured living trust completely avoids probate and helps preserve privacy. When you set up a living trust, you transfer the title of all the assets you wish to place in the trust from you as an individual to the trust. Typically, you no longer own any of the transferred assets. Everything now belongs to the trust. So there's no longer anything to probate when you die. Your estate will still have to pay final income taxes, but your living trust can help reduce estate taxes. If you name yourself as the trustee of a living trust, you maintain full control over all the assets. You can buy or sell as you see fit. You can even give your assets away. Although testamentary trusts do not become irrevocable until you die, living trusts can be either revocable or irrevocable. A revocable trust can be dissolved or amended at any time while the grantor is alive. As a result, it generally does not have any direct tax benefit associated with it. The grantor can sell the assets, change the beneficiaries, and even change the terms and conditions of the trust. A revocable trust is used primarily for property management, avoidance of conservatorship, and avoidance of probate. Most types of assets can be held in an revocable living trust, including real estate investment accounts, not tax qualified accounts like IRAs or 401ks though, and valuable personal property like jewelry, art, or antiques. An irrevocable trust, on the other hand, cannot be modified or revoked. Irrevocable trusts provide the benefits of a revocable trust along with the potential for estate tax savings. Once property is placed in an irrevocable trust, future appreciation of that property will not be included in your estate unless you retain certain interests in that trust. Although the gift may be subject to the gift tax, the annual exclusion may shelter part or all of the transfer. A special needs trust may be established as a standalone trust or incorporated into a revocable living trust. It's also important to reference the trust in your will. A properly executed trust can help provide for an individual's lifetime care and other financial needs while maintaining eligibility for government programs such as Medicare, Medicaid, and Social Security disability insurance. When someone with special needs receives a life insurance payout or inheritance directly, he or she could be disqualified from governmental assistance programs. A special needs trust avoids such an outcome. Some people prefer to leave an inheritance that enhances a family member's quality of life without enabling beneficiaries to become unproductive or financially irresponsible adults. Provisions in an incentive trust outline requirements or milestones that must be met before a portion of the trust money is awarded. Provisions may be drafted to promote education, entrepreneurship, public service, or philanthropy, to supplement earned income, and even to discourage certain harmful behaviors. The use of trust involves a complex web of tax rules, like we said earlier. So, before putting any of these in your plan, it's important to speak with a professional. There are several advanced trust strategies that can be used to enhance your estate and make sure it is not unduly taxed. One of the most widely used is the AB Marital and Bypass Trust. A revocable living trust with an AB provision enables both spouses to take advantage of the federal estate tax exclusion, allowing them to leave up to twice the applicable individual exclusion amount free of federal estate tax. Although some people think an AB trust strategy is no longer needed because married couples can take advantage of portability, the estate tax exclusion between spouses, that may not always be the case. An irrevocable life insurance trust enables you to use life insurance to help provide funds for your heirs, to pay taxes or other obligations on your estate that cannot be avoided. And a charitable trust provides a way for you to benefit the charity or a group of charities of your choice while reducing the size of your estate, which can give your heirs a tax break. Remember that the charitable organizations must be approved by the IRS, which means they must have tax-exempt status under the IRS code. So establishing a trust a powerful tool for managing and distributing assets according to your wishes after your passing? Yes, they definitely can be. So what is your next step? Is to begin researching the different types of trusts that are available, talking to a professional to see if any advanced strategies might be useful for you, and understanding which ones might be best suited for your estate planning goals. Next is getting your affairs in order. Just as you need to review your retirement plan periodically, you also need to revisit your estate plan. An annual review might be a good approach. As we discussed earlier, tax laws often change. It's important to be mindful of the composition of your holdings and the value of your assets as they change. Although you might not think the size of your estate is large enough today to worry about estate planning, especially considering that the federal tax exclusion amount is $15 million, there is a strong possibility that the value of your assets will increase over time, or that tax laws may change again. Your family situation could change too. So consider what might happen in the future if there's birth of children or grandchildren, marriage, or divorces. It's important to keep your will and your trusts and your beneficiaries current, so your assets will go to the people you want to have them. And keep in mind that estate tax rules and regulations can be very complex. Estate planning is too important to attempt to do it yourself without professional assistance, and a small mistake could tie up your estate for years. So would it benefit you to learn specific strategies to create or update your estate plan to help preserve wealth for your heirs? Yes, it would. So because you took time to watch today's video of our estate planning seminar, you have the personal opportunity to have your own clarity meeting to determine where are you now. We have covered many key estate conservation principles over this past time, and I'm confident that the information we've shared will help you feel more confident when planning for the timely distribution of your own estate. Understanding your options is one of the most important parts of your estate conservation preparations. So how can you put all this knowledge to work? Well, there's a couple ways you can do it. You can do it yourself, which could be a tremendous amount of work. You could work with others. You could work with us. And I hope you feel comfortable with what you've learned today and about our professional knowledge and the approach we take with our clients. Finally, you could procrastinate. Given the long-term ramifications of the decisions you must make, procrastination is not a prudent move. Of course, I hope you'll decide to work with us, and I hope you'll come to the complimentary, no-obligation clarity visit. I don't expect you to make any decisions now, nor when you come into the office. I only want you to decide when you're ready. As you feel you get to know us better, I feel that you'll feel more confident working with us. But then again, the choice is totally up to you. So the next step would be a complimentary estate planning discovery meeting. It's a no obligation meeting that helps you understand your options and help you create an estate plan that fits your needs. During this visit, we can discuss how to avoid probate, reduce taxes, reduce cost, avoid family conflicts, and create a customized plan for your family. You'll work with certified financial planners and fiduciaries who are legally obligated and required to act in your best interest, giving you a tailored, conflict-free financial advice. If you would like to learn more about how we can assist you, please give us a call at 817-210-3444 or email us at clientservice@stripmatterwealth.com. Again, the number is 817-210-3444, and the email is clientservice@stripmatterwealth.com. We look forward to seeing you soon, and thank you so much for spending time with me today.